Yes, sir.
3 appeals.
3 appeals.
3 appeals. Directed against the judgment of the Honorable Single Judge.
Very same judgment.
The same judgment.
3 appeals by 3 different persons.
No.
Same person.
This the background is like this.
Okay.
There are 2 writ applications were filed challenging the advertisement made by the state selection group. And the question which was involved in the advertisement is whether the qualification prescribed by the state selection board in the advertisement, whether it is in consonance to the UGC regulations. The Honorable Single Judge was one advertisement. So far the other advertisement is concerned, the Honorable Single Judge, since already the selection process was already high and already selection was made and appointments were already made in respect of different subjects except physics. So the Honorable Single Judge allowed that the appointment should be made in terms of the advertisement so far as that physics is concerned. And that has been challenged in the second writ appeal by some candidates here. But the first one is those who have already offered their candidature pursuant to that advertisement made by the state selection board. That is the subject matter of dispute. They have filed an application for grant of leave, and he also granted leave because they were not parties. They are not parties, so he also allowed that application already. Now, state has filed an appeal. The third one, state has filed the appeal challenging that judgment, saying that the state has the power also. State has not accepted so far of the judgment of Jagdish Prasad Sarma and other judgments. Relying upon that judgment, the state case is that these are all block grant schools, grant-related schools. So they are governed by a set of rules framed by the state government, one rule. So far as the qualification is concerned, they are not bound by the qualification laid down by the UGC because they are paying the state scale to these teachers, to lecturers.
One second. In other words, the UGC regulations apply to the conditions of appointment, recruitment, only when UGC gives the grant and not the state. If state is paying or reimbursing the salaries,
that is the state.
Then UGC cannot prescribe the qualification. Exactly this is answered in the negative by the Apex Court.
So far as the Apex Court judgment is concerned, that judgment, if you also see, since the education in the concurrent list and state has the domain also to make its own rule, so far the qualification is concerned, so the qualification laid down by the state government will prevail in respect of these colleges.
Is it with the assent of the president?
No,
you are referring to no. Question is, you can't read 309 proviso independent of distribution of legislative powers. UGC, as you rightly said, after the 42nd or 39th or 42nd amendment, education is brought down to concurrent list. But in the concurrent list, already field is occupied by the UGC Act, number 1. Then the rules that are promulgated under proviso to 309 are relatable to concurrent item only. It cannot override unless there is assent of the president. The rules are made or the law is made under 254, 254.
Conflict definitely.
Yes, as between central law and state law, in respect of matter relating to concurrent list, the central law will prevail over the state law unless the state had obtained assent of the president to the bill instead of assent of the governor. That is the law. This is what the Talloch, the Supreme Court has said that many judgments. I think the Karunanidhi versus Union of India. Yes, proposition this one. But, if that is so, now what remains?
The whole thing now to be decided in this case, because large number of, so far the Odisha state is concerned, large number of on aided education institution, for a different type of aided education institution, one is block grant. So far the state scale is concerned, they have fixed a prescribed scale so far these institutions are concerned. So that is why they have made the advertisement giving the scale of pay made for the state scale for the lecturers.
No,
so far the UGC scale is concerned,
it is not question of scale. UGC, the apex court said in 3 judgments, they are available. In 3 judgments, apex court said UGC is the nodal body to ensure upgradation of educational standards in all educational institutions.
That's it.
And educational standards are relatable to the prescription of conditions of recruitment. Suppose we want Palkiwala to be teacher in a law school. If that standard is prescribed by UGC, you are bound to abide by that.
Correct.
You have one option. The institutions have one option. Since they are paying the salary and it is not being reimbursed by the UGC, in such an event, in addition to the conditions which the UGC has prescribed, state can prescribe additional conditions. That's the law. That is the law. At least there is a big line of a curtain of decisions of apex court on that.
Therefore, the whole question for constitutional lordship, I have understood that whether the state laws with regard to the condition of service of the teachers, lecturers or teachers, and their scale of pay, and without those teachers are not getting the scale of pay from the UGC. UGC is not extending the UGC scale so far these colleges are concerned. Rather, that is a block grant. A portion of the scale is gone out by the management, and the rest of the scale was given by way of block grant by the state. In such a case, they have prescribed a rule. The state, of course, it is pursuant to an act, this Education Act. They have made a rule. That is for the state to place before lordships.
These are not 309 proviso rules.
Exactly, it is not 309, but it is pursuant to the
some
yes.
Other day, my brother was saying there is a Orissa Education Act.
Because that
yes.
is
Orissa Education.
Orissa Education Act 1969.
69.
So it is
is it enacted?
With the assent of the president.
With the assent of the president?
Yes. Orissa Education Act itself is the assent of the president. So therefore, it is a far-reaching consequence. So it has a
that was
prior to even, I think, amendment
to the constitution.
I could not get what is the conflict then.
Where is the conflict between?
Conflict
Because
is,
who are the agreed parties?
according to us, there is no conflict. According to us.
Yes.
But so far as this.
No, suppose they are overqualified.
Yes.
Are they debarred from appearing and competing?
No.
Oh, perhaps this question.
Now the whole question is.
Can we figure out
Better because my Lord friend also wants some time to take instruction in this matter. In fact, my Lord friend was suggesting us.
I will just for 2 weeks if the Lordship will fix. The
2 weeks.
Lordship can hear us out.
Yes.
Yes, broadly now we have
Yes,
understood what
exactly.
bone of
It
contention.
was not so. Yes.
No, you argued well. Therefore, we could understand.
That is exactly the.
Yes.
I was talking to my Lord friend also.
We'll take a date.
Yes, sir.
Pull down a
Which is
date from the
convenient
calendar.
to us.
On that day, we will finish up the matter. No date will be given further.
After 2 weeks.
Because any date.
Kindly pull down a date from the pool.
July 10th.
10th of July.
Yes.
July
We have kept
Many matters.
July 15th.
11th?
11th or 17th.
My Lord friend is
What's the next?
July
15th.
15th?
17th.
70?
Yes. Okay.
70. Oh, thank you. Give the
Yes,
judgment. So the law is much
Yes,
settled.
yes.
Much of the law is
You're
settled.
absolutely correct. Now, only question is whether that is a
Conflict or
Conflict
not.
of yes.
Conflict may arise. On that itself, there are judgments.
Right.
Shirvai writes,
So that's right.
conflict may arise not only during direct conflict. He gives wonderful example. Central law permits 5 liters of petrol. State law permits 3 liters of petrol. Is it a case of conflict or not? So beautifully he has discussed in 4th edition, Shirwai's constitutional law. Very, very, this one.
Yeah, appearance will be noted. I'm for the UGC. Yeah, appearance will be noted.
We will not note anything now. We will resolve this matter on
For other reasons, why not?
Rest of the matters.
So please write your, in the paper, because there's so many cases, so they will be public. So in each case, please write whoever are appearing, including us.
that way. Okay.
The rest of the matters.
Rest of the matters will
On
distribute
consent of the parties, list on 17th.
70. Consent of parties.
17th.
Under item 43.